session yesterday? Yes, even in absentia, Judge. We hope you have the same today. Before we start, let's bow down for our prayer. Our kind and loving Father in heaven, come to you this morning. Father, we thank you for this day and for this chance that you've given us to be able to meet and discuss some of the pertinent issues affecting children in the justice system. Lord, we ask for wisdom, we ask for your guidance, and we ask for proper time management today, even as we proceed and finalize on this event. This is our prayer, may to be experienced in Jesus' mighty name. Amen. That's when you get your, the moderator who is a Christian. So if you are an atheist, I apologize. So my name is Effie John Atieno. I'm the Access to Justice specialist at TDH and one of the organizers of this event. So I'm happy to welcome you once again to this second day. And today will be a bit more practical. Yesterday we were having conversations, and we hope those conversations triggered something in your mind, your creativity, your thinking about where you think the laws need to be amended, what you think we should do in terms of policy, in terms of guidelines development, and basically where we should go in terms of child protection, access to justice for children, strengthening child justice, and all of us working cohesively to ensure the justice system works for the child. If you remember, we had the children presenting here and they made some very important points, and please to us as the adults in the room that if we're having a conversation about them, without them, then we are working against them. And we hope not to work against them. Some of them are not able to join us today because we couldn't pull them out of school for 2 days. So we hope you'll bear with us for that. Without taking so much time, I would like to introduce some of the speakers for this session. Today, as I mentioned, we have a very practical session as opposed to yesterday, so this will involve all of us. So make sure you're here, especially in the afternoon, because we'll be working on the roundtable discussion to develop the draft framework on diversion as a unit. Everybody here, you have different experiences, different expertise, and we'll be bringing all that on board this afternoon. For this morning, we're going to have Ms. Jemima Luda, who's familiar to all of us. She was here yesterday, being a moderator, a woman of many talents. Then we have Honorable Jackie Kibosia, who's yet to join us, but she is on her way. And our keynote speaker, Professor Pielo Lumumba, who is already here with us, just waiting, having a short session, and then he'll join us shortly. And then we'll have an integrated case study and practical simulation of practical inquiry, diversion, and family group conferencing. And the participants will be, if you are a member of NCAJ Standing Committee, most of you will be participating in this session, and we look forward to seeing you. It will be run by the NCAJ Standing Committee on Children Matters. And then finally, we will have the round table discussion, and then we will officially close the session. Karibuni sana. At this point, I would like to welcome Ms. Aluda. Hearty round of applause for her.
Okay, thank you very much for this particular opportunity to share with you about the practical experience of AJS and the need for us to be able to look at children matters from the lens of alternative justice systems, and especially in the criminal matters. So first of all, just to, as what you can see, the inequalities that we have, I saw the children here discussing about inequalities, and I saw the magistrates telling us, whereas our problems is my child does not have a phone, so it's a case that the judge has to deal with, or it has no access to internet, or the holiday destination that we chose is different. So we are going to just Madeka to assist us to choose which holiday destination for this child. But now we have this child in terms of, who in the realities that we have. These the children now we can say from the ghettos or the realities that we have. This is what we have in terms of the children that we are going to advocate for. The ones that are Honorable Kibosi was talking about, they're up here. Okay? And then there are those of us who are trying to reach that particular section, but we can't. So this is the reality. When you say that you're all giving an equal ground, like what is happening in the CBC, this is what is happening in the CBC. We have children who still cannot access most of these facilities. For instance, I'm a board member of a public school, which is among the top 5 in Nairobi, and one of the problems they have is the toilets. Yet, maybe my child, the problem they have is the food they're being served, they're not being given pizzas. So, but now we're talking about equality. So we can see that we cannot still address the issues even in the justice system. As much as you're talking about CPUs, you're talking about a diversion. Some of us can afford to take our children for psychosocial support, and they have mental challenges, taking them through to a counselor. But now, these other children, they have nothing. So even as you're going to have the conversations about which parameters are we going to put forth, we can't apply the same standards across board, right? Equity is saying that, okay, the ones that have nothing, we uplift them. But now the question is, for how long can you stand like this? You can't stand like this for a very long time. What we want is just liberations, a safe space for our children, justice systems that can work for all, irrespective of where they come from, irrespective of their age. We just look at liberations, we remove all the barriers that we have, and that's the only thing that we need. In terms of the socio-economic implications of incarcerations, even if it's the 5 days that we put somebody in custody or the children in the CPU, this is what happens. So when we developed the diversion policy, at that time we had 55,000 inmates. I know now we have at 64,000, an increment from 2017 until now. So at that time we used to spend 98,500 per inmate. So we can talk about 55,000 when they're incarcerated. Remember, we also still take care of them. So it's 5.5 billion at that time. Now, of course, the costs are higher because the prison population is above 62,000. At this time, it was 55,000. Most of them are petty offenders. As you can, for the children, like I've done, I do pro bono matters for children. There's this interesting case of preparation to commit a felony. So most of the children, especially in the ghetto, are found in this space of the so-called petty offenses. You're being told that creating disturbance, you're creating disturbance according to a drunk and disorder, you're drunk and disorder according to good standards. Okay? And in fact, that if you go back to the inequality framework, when a rich person drinks, I use Daktari, allow me to use you as an example. When Daktari is drunk, he'll be chauffeur-driven home. Okay? For those of us who are in the middle, when you're drunk, what will happen? You take an Uber. But it's only for the poor people when they're drunk that they just walk home because they have so many problems, they can't even imagine. And even whatever they spend, it's just like 100 shillings to take the little changa. And then they're arrested for what? Drunk and disorderly. So you can see the inequalities, how they apply. So even for our children, when they are found with the one Msokoto ya bangi, they'll be arrested, yeah? But for me, if my child is found with it, in fact, I give them the space to be able to do. Those are the inequalities that we're dealing with. So if you want to address children matters, let's just remove all the barriers. And so we have so many petty offenders, and the question we ask, and for those of us who are dealing with children, do we really rehabilitate our children? Because when they get in custody, they come out, we still have high rates of recidivism. Why? Because our institutions have not been structured good enough to be able to actually rehabilitate the offenders. Number 2, are prisons correctional facilities? Are they really because when somebody gets out, you're being told you cannot get a certificate of good conduct. You have to stay for 10 years. So the question is, so what was I doing in prison? If when I get out, I'm still being termed as a criminal who cannot be able to enjoy the rights that everybody is enjoying until 10 years. So what was I doing in prison? So if you didn't know that, that's the question. What was I doing in prison? Because when you get out, you're still being told you're not good enough to participate in the affairs of the nation for the next 10 years. So were you corrected? Were you actually rehabilitated? And last but not least, are we moving in the right trajectory? As I told you, when we're doing the diversion policy in 2017-2019, we had 55,000 inmates. Right now, the numbers have increased to 64,000. So you can imagine with all the reforms that we put in place, with the policies that we've established, what is not happening. And so it's a call for reform for us. We move from this side of holding facilities, CPUs and everything, towards now restorative justice, where we're talking about participation, community engagement, voluntary, so that you can have a discussion. And that's why we have this particular conversation today, to see that we all come together to deal with issues of somebody taking responsibility as an individual, participating fully for us as a community to be able to rehabilitate this person fully. Just to let us know, when somebody has stayed in committee for 10 years and they come out, and this is your brother, will you welcome him? Will you welcome him? And this has been the case. Even these ones who are released some times back in May, most of them when they come out, nobody accepted. So the civil society has to establish now homes for them, look at how they can be able to settle them, because where they were, nobody accepts them. And that's the thing that we need to think about. And so we have had a focus on retributive justice, as I've told you, for the last 7 years. The country has put a lot of resources in terms of institutions, in terms of building, adding even officers, probation. DPP has employed more prosecutors, the judiciary has employed more magistrates. We've been looking at crime as a violation of the state. We've been looking at crime as an individual act, and we have no role in this crime as a community. And we've always been thinking that when somebody goes through the criminal justice system, then you control crime. And the question is, have we been able to control crime? Because all these years, we still see more reoffending and more offenders and more offenders getting into the system. We've still been looking at punishment is effective. Like when I send you to prison, then that is an effective punishment. And victims have still retained a peripheral role in this process. Like, you come testify, go home, we are done with you. Our focus has been to blame the past. So what did you do? So what happened? What did it do to you? What happened? We are not looking at the future of preventing. We are just looking at what did you do? And tell this court what happened. The 5 wives and 1 husband. When, how, what, and all that. That has been our focus in the criminal justice system. We are never looking at how do we prevent, how do we look at the future, how do we assist this person even in the future. And we've been emphasizing on adversarial relationship. Our relationship has been more adversarial. So today, we want to shift to look at it from the restorative perspective, whereby the community has a role. Even in this person committing a crime, we as a community have a role to play. That this person has now, even every child is very innocent at birth. Have you seen the children at birth? They look so lovely. They look like angels. But you as a community, there's something you've done that has made this child get into where they are. Remember the story you had about land disputes and issues of displacement, where children are living in camps, and at the end of the day, now they get into crime. So we need to look at accountability by responsibility. Punishment should be defined by somebody taking responsibility. I accept I did this. I accept I'm ready to reform. I accept I'm the one who pushed you to do this, and I'm ready to assist you to walk through this. And let the victims be at the center, and let's have a dialogue and negotiative normative. And that's what we want to discuss. Can we encourage more dialogue and negotiations? So there's a call for reform. It's a very interesting quote from Windberg County. The district attorney Eric Sparks said, "Seeing firsthand some of the conditions we subject people to in these facilities emphasizes why we must urgently end our over-reliance on incarceration and embrace new visions for public safety, accountability, and rehabilitation." She asked her question, how many of us have spent in a cell? I've gone into a cell. I've seen how a cell looks like. I've been to community with the young children, and you can see the distractions they have. I've done a lot of pro bono matters for children. I've never even followed up on the payments, because for me, I feel like this child needs a second chance. So for me, I've never even made application for those payments of theirs, but look at it, saying this child needs a second chance. I did a matter of those sorts of preparation to commit a felony. And they can see, you arrested 3 children, 1 person is almost been taken to prison, or been taken to this. The other, you don't know what happened to the other 2. And there were 3 of them. They were just walking, There was a disco huko penye wanapokosa kwa shuleni arrested at all, preparation to commit a felony. And I'm so happy that actually through submissions and everything, this child was acquitted. So you can see, if you look at these conditions where we subject our people, if you go to prison, if you work in prison, I've worked in prisons, most of the prisons in this country, then we still have to embrace and have a new vision for our system. Article 157.11 of the DPP, of the Constitution, says that when the DPP is exercising their mandates, they need to look at public interest. And public interest, if you define it, it's called about community interest. And the community interest now looks at beyond just taking somebody through the system, but looking at it, how can we be able to avoid abuse of the legal process? How do we prevent and avoid abuse of the legal process? So that is the main focus for us today. How do we embrace Article 157, Sub-Article 11? And more importantly, Article 159 of the Constitution, which says that we need to embrace reconciliation, mediation, traditional dispute resolution mechanisms, so that we can be able to ensure people can get justice without due technicalities and procedural matters. So how do we focus our minds to ensure that we can be able to embrace operational Article 157.11 and Article 159.2c? And that's the conversation we have. And why should we do that? Because when people face grievances, only 17% go to court. Okay? But out of this 17%, what do we say? There's a case backlog. Out of this 17%, we still cry and talk about case backlog. So we are asking ourselves, how do we deal with that? But more importantly, 64% go to other systems. And the question is, how do we now build these systems to become more effective and become better? So we cannot just shut our eyes on it and say, I'm not concerned about the 64, my only concern is 17. Because as I've told you, for the past 7 years in the criminal justice system, I've worked in this system for a very long time. Even our first conference of the National Criminal Justice Conference, the first one, we still had 55,000 inmates. So now the inmates are increased. With all the reforms we've had, with all the policies we've had. So what we need is, how do we build on this 64 so that we can be able to even increase and empower them? And that's the structure that we need to develop today. And so some people ask, what is AJS? What are these systems? So this shows the systems that we're talking about. The 64% you're talking about. Whenever there's a dispute, we try to resolve it at a personal level, at a community level. We try to resolve them through customary models. Like, you can go to your neighbor, somebody has stolen. Before you take them to court, you ask, can they return? Can we, if somebody has been, an assault has been committed, can we be able to guarantee the cost of taking the person to hospital? Most of the disputes in the community are resolved through the chiefs. Even the petty offenses, most of them are resolved by the chiefs, by the Nyumba Kumi. And the first thing they'll tell you, I went to the chief. I went to the Nyumba Kumi and reported to the head of our estate. So most of the disputes are resolved there. The religious leaders play a very important role in our communities. How do we work with them? How do we tap on this existing mechanism so that you can be able to even enrich them? They're able to deal with disputes even more effectively and cases more effectively. How do we enhance social dialogues? I told you the example of Othaya, whereby through social dialogues we're able to deal with the issue of Mungiki menace in Othaya. So how do we enhance the social dialogues? And now, the little percent that goes to court, how does the court also perform its role under Article 159 as a judiciary who has been given the mandate to ensure that these other mechanisms are working? And so we have 3 types or models that we want to build, and even as we're developing structures, we need to have structures that empower this. Here, the community level, can we empower the community discussions? Can we empower the community taking their role in terms of cases that they have? The cases that, what is the prevalent issue in this area? Can we come together and deal with this issue? Because nobody wants to see their children not going to school. Nobody wants to see their children being arrested and detained. Nobody is happy to see their children getting into gangs. You see parents crying in court. My child has gone into this gang. I don't know how to get this child out of it. Kindly assist me. And you're an advocate. So how do we build the communities? Because I can assure you that to live there, but they found themselves there. But how can we make it a better place for them so that you don't say anybody who comes from Korogosho is a gangster, anybody who comes from Korogosho is a criminal? So how do we use the community structures to deal with crimes and make the children have a safe space? Secondly, we have this model of the civil society and the state actors. And yesterday we were able to see what civil society is doing, the two examples that we had. How do we work with the civil society in their role in terms of advancing for child justice and ensure that we strengthen the justice system? How do you work with the development partners in embracing alternatives to court? Then we have the state actors, and I'm glad that we had the police here. We were questioning the police, we were questioning the Department for Children's Services. So how do we build on the probation? There's somebody from probation, somebody's from police here. They handle most of these cases at their level. So how do we empower them? The chiefs. It's quite, we did invite the chiefs, and from today I thought I want to, I request that we need to have a chief, somebody from Ngao, because they deal with so many of our cases at the community level that even what the police deal with. Most cases are handled by the Ngao. So how do we empower them? So that even as they exercise their role as through chief barazas, through forums, they can be able to advocate for child justice so that communities can be able to change. And lastly, the court must be given its due respect according to the Constitution. How does the court now annex itself to be able to empower these other mechanisms that exist? And that is the court annex. So we are working with the court to work with any of these models, but also to work with the communities. And that's why we have court users committees. We never used to have that. But the court was told, you need to listen also to your stakeholders and get feedback. And through that feedback, we've seen justice changes in the justice system. Oh my God, that's it. Okay. So I'll go to the issue of diversion. When matters are happening at the community level, before even they come to the state actors or the police, the communities can exercise diversion. And that is called a community, whereby the community can say this child has found himself in this particular arena because we as a community have failed. The parents are not here, the child lives with the grandmother never gives his child food, or the child lives with a step parent, the step parents always mistreat these children. So how do we as a community start building, empowering these children so that they can be able to get out of the system that they've gotten themselves into? I remember we were told yesterday that most of the children in the ghetto are the breadwinners in the family. We need to come together and deal with that issue of children being breadwinners at a young stage or a young age. When it comes to the police, when matters come to the police, there are cases that the police do not even forward to the DPP because they feel like they can be handled at that stage. So we also need to deal with the pre-charge diversion before the matters even reach to the DPP. Because we are looking at this child, we don't want this child to go through this horrible system and coming to court and all that. How do we empower the police? How do we empower the chiefs so that they can be able to exercise their mandate to ensure that we deal with these children and strengthen the system? When the matters come to the DPP, because the DPP still falls under the state actors and they're exercising their power as prosecution. When the matters come to there, then you're dealing with the DPP's diversion at that particular stage. So how does the DPP now work with other stakeholders to ensure that you have systems and structures? If I'm diverting this child, then somebody is also taking this child. It becomes a chain. If it is a mental issue, I'm directing this child to be taken through mental system, mental health, whatever system. So we have a system. How do I divert this child to maybe a civil society that is going to give safe space for this child? How do I divert this child to be able to go through training? Because this child has refused just to go to school, and the mother is telling you, all I want is this child to go to school. So now the DP needs to have structures to be able to ensure that this child is not left hanging, but is able to be connected with another system. Then when it comes to court, when the matter is in court, so now the court applies its role under Article 159. And at that particular stage, even the court can see this matter is not fit for me to be able to take a plea, like what Judge Honorable Kibosia told us yesterday. This person has already stayed in custody. I don't think there's any even need for this child to take plea. But you don't leave the child hanging. You don't just say that you are acquitted. You say that if it's a parent, the parent needs to take responsibility to ensure that there is no reoffending. Because remember, we don't want this child to be left hanging. We want this child to be taken up by somebody else. If it is school, you're even telling the child, please, from here, ensure that you go back to school, you know. So at least it's a system that is working for the child. That's the only way we can talk about strengthening child justice system in criminal matters. Thank you very much.
Thank you so much, Ms. Aluda. Can we clap for her one more time? Thank you so much for the challenge. And at the end of it, the conversation is the same. What can we do better for the children? It is not for us as legal practitioners. It is not for us members of the bar or the bench. It is for the children. At this point, I would like to welcome our next speaker, Zachary Omwenga from the Office of the Directorate of Public Prosecution. Karibu sana.
Good morning.
Good morning.
As you have been told, I'm Zachary Omwenga without N. I have been a prosecutor for the last 25 years. During my tour of duty, I've also been the first legal head, Minister of Gender, Children and Social Development, on secondment from the Office of the Attorney General. During my time at the Ministry of Gender, Children and Social Development, we started this discussion with Honorable Nikal, Esther Murupi, the minister then, and Madam Odol, professor. At that particular time, we had taken into account the United Nations Convention Against Children. We had also we examined also the African Charter on child rights. We also examined our child rights, our Children Act. Other than that, I have had an opportunity to practice in areas where you will have a lot of dual representation, especially those from the civil society. I have had an opportunity to serve in Embu. I served there for 9 years. Straight after that, I moved to the Ministry of Gender on my own reason, because it was advertised and I applied for it. Thereafter, I was recalled back when my colleagues resigned. Then I was dispatched to Nakuru, where I served for some time. Thereafter, I moved to Eldoret. From Eldoret, I moved to Narok. From Narok, I've worked in Busia at the borderline. My last destination was in Nyandarua. There's a reason why I've decided to take you through that. I want to start by saying that I have had an opportunity to serve in the whole Constitution and in the new Constitution. There's been great change in our legal practice, even to delay. The first time I had a discussion like this is when we had a training with the Canadian Bar Association, similar to what we are taking through. And the next time is when we had the Japanese training us on it. That may not be concerned for today. I was informed last evening that I'm supposed to make presentation on the practice of AJS in criminal matters, related to children matters. That reminds me of the Children Act 2022, which brought in several changes, and we call them sweeping changes, and actually brought changes the total length of the practice in juvenile justice. We may also appreciate that that did not change our constitutional provisions, nor did it change the mandate of the judiciary where it comes in, because we get our powers from the Constitution. I am aware we talk about Article 159, and as it was coming in, there was a representative who made a presentation on it and touched part of it. I am not going to make an outright statement. I belong to the school of thought when you deal with people who are converted, you just express your views, but you don't tell them to follow it. You ask them to check the law and see whether you are right or wrong. When you read Article 157, 159, I'm trying to run away from mentioning 157 because I know a large number of people may sometimes not believe that that provision applies. I wish to deal with Article 59 of judicial authority. Of course, you read Article 159, 1 and 2, it is very clear. And there is one thing I would want us to go and think about. What's the difference between alternative dispute mechanism or alternative justice mechanism and alternative justice? Of course, for academician, I'm seeing my civil judicial review lecturer who taught me judicial review around. I think I will leave that to them. But when they came with Article 159, it says the judicial dispute resolution mechanism shall not be used in a way that contravenes the Bill of Rights, is repugnant to justice and morality, or result in outcomes that are repugnant to justice or morality. We all of us know about the repugnance clause, and I know there's a lot of debate about it, and I will not want to go to the debate because I'm making a presentation and leave the seat. The debate, I will leave it to you. Then you look at 159 is inconsistent with the Constitution or anything in the law. That does not mean when it gives you all these powers, you act in a manner that will overrun the other provisions of the Constitution. You must bear them in mind as you exercise judicial authority. And that's why we are reminded all the time that let's not go beyond some limits, because our Constitution architecture has provided the limits of every agency, including the judiciary, including the ODPP, including the police, including the jury department, of course, and other agencies. What sometimes people call the control function. That is intended to check our limits. After the 2011 Constitution, several procedural laws were amended. Several procedural laws were amended. One of these procedural laws which was amended is the inclusion of Section 59A to 59D of the Civil Procedure Act. And in this one, they were very clear. They have talked about mediation, I can talk about arbitration, differences of cases, and that 59C and that alternative dispute resolution methods. I think this, to me, was trying to operationalize Article 159. It goes all the way to 59D. Unfortunately, there are provisions in our criminal procedure code which were not removed. That is Section 176 of the criminal procedure. I think those who probably are of the view that the section was amended, you let me know. I am open to running. I belong to the school of thought to believe that you learn all through. You may or a few at a later time you get converted, and as a lawyer we get converted daily because you make presentation in court. Somehow you are told that your presentation was not up to. You lose. Then if you go to the High Court also, the High Court may tell that judge or Machedu may have told you that you also, the Machedu was also wrong. They may have told you a few. Now, 176 still remained in our statutes. In all cases, the court may promote reconciliation and encourage and facilitate the settlement in an amicable way of proceedings for common assault, for any other offense of personal or private nature, not amounting to felony and not aggravated in degree, on terms of payment of compensation or other terms approved by the court, and may thereupon order the proceedings to be stayed or terminated. That is how far we go with the criminal procedure. And remember, they said not inconsistent with any written law. That's what they have said. That's what Article 153 has said. Then I also I do some bit of reading because I believe practice is about reading. It's not about how loud I can be. It's about how reading is. I've had the opportunity to read the criminal procedure bench book. This bench book, when it was the committee, members of the committee were going around, they extensively engaged. During the extensive engagement, I happened to participate. It was headed by retired Honorable Justice Lady Justice Okwen. One of the judges have appeared before several during my time as even when I was a young lawyer, when I used to be in Embu. If you look at page 68, in that book they have included 176. They have an area where they have tagged on original dispute resolution mechanism. They were aware that section 176 was not amended. And remember, 159.3 talks not inconsistent with the Constitution, period of right, or any written law. Only in that stream the Constitution has referred to written law. I don't know whether that is, and I'm aware the Secretary of the Constitutional Reform is around also. He will be able to teach us, to tell us what were the discussions at Commerce when they were coming with Article 159. As we just got the end product and we voted yes, overwhelmingly. And I keep on asking myself, my mother was around in 5 years, didn't go even to class 1, but is brighter than me. When I make a mistake, he's able to correct me. And sometimes when I reflect on one and I fuse, I realize he's right. But I asked myself, the value of their thought and the value of an informed thought, that's a debatable issue. Of course, not for today. But of course, they will be learned by this, they will be guided by this Constitution, so they have the right to participate, and they made that decision, and we have voted. The question is, are we living in the Constitution? That is a question I'm not going to ask you to answer. Don't even ask me whether I'm living it, because you will be judgmental. Probably I'm not living it because you are not living it. If everyone was to live the Constitution, every one of us was also to live the Constitution. But if some of us live and some of you don't, the case is as good as mine. In the case of Kinyua Kwalo versus the Office of the Director of Public Prosecution, the High Court petition number 285 of 2016, the court directed that while the court may allow alternative dispute resolution mechanism, the DPP must concur and the parties must agree. And I think I have had an opportunity to see. I have seen the spirit in the HS policy, where they have said how you can approach that. But in that spirit, it provides for our participation. And I know we may have a lot of argument around it. I have listened to most of you talk on TV on what are the provisions from section 217 to 244 or 241. I am a keen follower of when mother's children are attacked. And during my listening, I do not know whether I'm the one who sometimes get it wrong. If we were to resist the role of the DPP under 157, Article 4, where the DPP can direct the Inspector General to investigate and report back. I have heard a statement that proceedings under the Children Act are not criminal. partially, I may agree. But if you read, is children in conflict with the law? Conflict with what law? It's not civil. It's conflict with criminal law. The same provision under 238 and 239 of the Children Act provides on how you go through a trial and the final outcomes in terms of sentence and what will come. Then if we make a provision for sentence, then there must be the criminal aspect. But we are also aware to treat a child like a child. Don't treat him like a person over 18. We are also aware of Section 221 about maturity of criminal responsibility. That used to be in the previous penal code where the majority age was provided and it was among the exceptions. That, to me, I think there is some role of prosecution in the entire chapter. And the prosecutor, when participating through 217 to 241 or 244, those of you, my memory may fail me. If I quote the wrong one, please don't punish me. But I think I'm to the point. When I look at it, I usually see the role of a prosecutor. Underline it with Article 157. We can't close our ears and say, ignore. Because as far as I'm concerned, there is Article 157 which said Parliament may pass a legislation. In that legislation, they may give some powers of prosecution to another chance. So far, I highly doubt whether Parliament has ever passed any legislation. That leaves the DPP the only prosecution authority in Kenya at the moment. I know there is some acts where they have attempted remotely to come with those powers. The other issue I want you to understand that the Office of the Director of Public Prosecution is the champion of alternative mechanisms of sorting out criminal matters. Before the coming up with the Children Act, the office had come with a policy, the diversion policy. Someone may ask me, what is the basis of the office coming up with the diversion policy? My reading of Section 5 of the DPP Act of the Office of the Director of Public Prosecution, subsection 5(1)(c), it says, pursuant to Article 157 of the Constitution, the Director shall, I'm going straight to C, because I know I have no latitude of time to deal with other unnecessaries which probably may not be your concern, formulate and keep under review public prosecution policy. Based on that, we have come up with the policies, and I hope you are aware when we had a very consultative approach when we were coming up with the decision to judge guidelines. As far as I can remember, all agencies did participate. And that was 2017. Is it 2017 or 2019? 2019. In that one, they came up with decision to judge guidelines. It went through the process, public participation, and anti-refutation. Please don't ask me further questions beyond that. That will be another time for debate. We came with it. In that decision to judge guideline, we have mentioned alternatives to prosecution as one of the techniques the prosecution authority will use. What does that one mean when you talk about alternative prosecution? It means instead of taking you through the prosecution, we will use the alternatives. And we have said that must be, that option must be exercised objectively. One of the issues we have prominently mentioned in that decision to judge is children matters as a matter of right should go through diversion. How you do it? You may choose to do it as you violate the Constitution, but you may but that is been provided for. That came earlier before the Children Act. Those of you who are good readers, you can get it in our website. It's a good document, according to me. It may be a bad document, but according to my assessment criteria, I'm convinced that is one of the progressive documents we have, which captures what you people are struggling, including saying that the ODBB is a threat to HAS. When I'm saying, I don't say I've had it, I've been told on the face, Professor. If you may be told, I'm among those who call it the way it is. I've been told it on the face. Where we were having the argument whether in a bar, residential place, I was told. If you didn't tell me, don't say I've never told you, but I've been told as such. I have had situations where I have had where even court say, I order that you go to the mediation attacked. Prosecutor, I refer to the matter of the mediation. We are just adopting the civil practice to criminal law. Because I'm about to finish. In the morning, I've been ready to come because I was dealing with, I wanted to put system in place to deal with the matter coming to court for revision. In that revision, one of the directions given to us, they were given, we were to file a reply. Isn't it? But we obliged. Don't ask me why. I think the professor will tell me that in addition you don't need to file a reply, but we obliged because we never wanted to antagonize the judicial officer. But in my mind, I realized that it was just transporting civil practice to criminal law. But we had nothing to lose. We restated the law. But it was just transporting. We all of us make mistakes. I have had an opportunity to appear before the Court of Appeal, and one of the questions they asked me when they wanted to overturn a judgment, Mr. Mwega, when the court was making this error, what did the State Council do? Then I told the judge, my rights and my right, there were two gentlemen and one lady. I think this council has practiced before that judge until it has become law. He may also have been wrong the same way the judge was wrong, because I was conceding to it, and they had approached me by asking me, please comment about this particular. Professor will confirm that when we used to appear at the Court of Appeal, they take you there, address us on this point. And you are able to know now, you are totally finished. Unless you have been in the game longer as professor, you will be able to navigate around. But those who are young may not be. You will get tongue-tied. They asked me a straight question. What did the State Council tell the judge for this error to have been committed? I told him, probably my rights. The State Council may have been wrong the same way the judge was wrong. Because he may have also practiced before this court and they adopted this as a practice without anybody taking it on appeal, isn't it? You know, if you don't take a matter into appeal, the High Court still finds it, isn't it? I got away with it. I made my submissions. Finally, they set aside the judgment and ordered for a trial. Because I want to be very specific and very emphatic. I know our alternative prosecution is a matter which is being investigated. I'm done, madam. Don't be patient. I'm not touching the dangerous area. I'm very careful. I'm invoking the 16 laws, undeniable laws of communication. Have you ever seen that? 16 undeniable laws of communication. If you go online, you will find it. Undeniable laws of communication. I am employing them, even where I have over different few. I think now now I have abruptly become old. Not because of my age, but because of other conditions which can make you old when you are young. You have disorganized me, but let me proceed. As I was saying, as we interpret also some of these provisions we keep on flashing out, make sure we do it all safe. Don't just pick provision 1 and 2 and forget the proviso. And I found that practice very common with every one of us. You choose to read provision A2, but you leave 3. It's a practice we are all of us guilty of. And if somebody confronts you, Mr. Omega, you have told us about 1, 2. Are you aware of 3? That's the time you will go to 3, isn't it? Equally, because of importing, and I will have to confess, and I think the practice has extremely changed. And that will be my last statement, and I don't know what we will do, because sometimes we bought something and practice for a long time until you think it's wrong. My last statement, and that will be my parting shot. When I joined prosecution, we used to have police prosecutors and the constables, senior sergeant, corporals who were prosecuting. I approached my bosses then and said, I thought Section 85 was very emphatic that the police officer to whom power can be delegated to prosecute must be an assistant inspector before they change it to a public officer. I remember one of the senior prosecutors then told me, we have done this for a long time. And all along, the constables, sergeants have been doing it. And of course, as a young prosecutor, I gave in. And please learn to give in. Don't be absolute. Law keeps on changing. When I gave in, come 203, the Relema case came, when the court says prosecution before an incompetent prosecutor. That was it then. The last one, Madam, I've just remembered, is when we were dealing with Section 625, public officers who can set aside. We raised it, we argued before the judge, states agreed with us, and they said the state officers cannot be suspended. Until a 3-judge bench dealt with it, and they say, sit a 3-judge or 1-judge bench. The only judge I remember whom I can remember is Justice Mumbi Ngugi, who did a very class judgment, and that time we were vindicated. So for today, if you see me having a different opinion, time will vindicate us. So don't get discouraged. Be aware that the office of the DPP are the champions. They end that alternative justice mechanism are before the Children Act. And you can get it from our decision to judge guidelines. The only issue we have is when a court takes over and starts directing the DPP, that this thing goes like this. We are aware we have been given a controlled mechanism. We have not been given at COVID-7 as a chocolate we keep on taking when we want. If we exceed our powers, we are controlled on the ground of illegality, irrationality, abuse of the process, not acting in the wide interest of administration of justice. That's the only time a third party will come in and control, isn't it? Other issues, please don't engage me on it. Thank you very much. I was told last evening, I am unlucky that I didn't come with a presentation. I would have come with one. Unfortunately, it was last evening I was cleared to come and make a presentation. And within a short time, I have not made the best presentation, but I have tried. Because what I have said is from my head. Probably my memory may be failing me. So if I may have made a quotation which is not consistent with the law, please don't bounce me. Bounce my memory.
Thank you so much. For someone who claims he's old and was not prepared, that was pretty good, right? Thank you so much. When we grow old and we say our memory has failed us, may we be like that. At this point, I'd like to welcome Honorable Jackie Kibosia. Again, someone who's not new to us. Yesterday, she was put on the spot here by the children, and she held her ground. She did well, and she reassured the children, which was a great thing to see. And at this point, I would like to welcome her. She's a magistrate at the Milimani Children's Court and a member of the NCAJ Standing Committee on Children Matters. And once she is done, she will then be able to invite Honorable Justice Teresia Matheka, who will invite our keynote speaker. Karibu. Round of applause.
Good morning to our distinguished guests and ladies and gentlemen. My name is Jackie Kibosia. I sit in the Children's Court at Milimani. technical problem. So as we wait for my presentation to be set up, we can do a small exercise. I've been given 2 minutes for a small exercise. Because we are talking about children, can you draw a picture of yourself? Draw a picture of yourself. I mean, we're in a child-friendly space, isn't it? The children's court, so that's what we tell the children, draw a picture of yourself. We use that a lot. We use expressive art in court. We ask the children to draw pictures, and we have people interpreting those pictures for us. So you've been saved by the bell. Okay, so mine, the standard of 15 minutes. I'll try and make good use of the 15 minutes. This is the current UNICEF statistics on detention for children. Maybe this will help us know where we are at. That is, we have Eastern and Southern Africa doing very well in terms of detention. I think this one we need to clap for ourselves. The justice system has worked round the clock. We are below the world average. So the world average is there 15, and Eastern and Southern Africa is competing with West and Central Africa. So the only competitor we have is, we need to start looking West Africa, maybe exchange practice. We see what they've done, because look at North America, Latin, South Asia, they're leading in terms of detaining children. So our AJS is working. So again, I'll go straight. What guides this court is the paramountcy principle. What were the ground rules? After? Yeah, otherwise we'll eat into my 15 minutes. So we look at the paramountcy principle. This person coming before the court is a child. And the guiding principle is the best interest of the child. And if you look at Article 53, I'm glad this article comes before all the articles, 157, 159. 53 comes here, and we are told we should have the shortest appropriate period of time in detention. I don't know what that means for us. Not to be detained, except as a measure of last resort. That is what comes to my mind every time I sit there as a court. That the Constitution tells me that when this child appears, I should not detain them except as a measure of last resort, and when detained, to be held for the shortest appropriate period of time. As Milimani Children's Court, we have signed a contract, a performance contract, that 6 months is the time we should finish that matter. So whether you're detained, you're proceeding or not, we must finish within 6 months. I have signed it, and we have committed to it. So we are compliant in terms of the shortest period of time in remand, and also processing that matter. This child shall be separated from adults, and in conditions that take account the child's age and the sex and age. So detention facilities have been addressed here. Don't detain them with adults. We have a child who was detained and molested in a police cell. In fact, when they tell you their stories, when they appear during preliminary inquiry, you get shocked at the fact that people could not notice that this is a child. In fact, when I was in Makadara, I was told, at times just look at the beard. I don't know whether that is the correct measure of knowing. Look at the age of the beard. If this is a child, you would know. If they have no beard, suspect first that they are a child. That is what I was told. As a way of assessing, is this a child or not? But for me, you can know a child. I think we are all intelligent enough to know. This one is a Gen Z, this one is Alpha. You will know. It's just common sense most of the time. And I prefer we start by looking at them as children first, then now we discover they're adults later, than the other way around. Treat them as adults, then you later find out that they're children. So, of course, 159 on judicial authority, again, that is what guides the children's court. Justice shall not be delayed. We have contracted for 6 months. We shall not delay. Now, where does AJS come from? Traditional dispute resolution mechanisms is what we use, recognized by the Constitution. And the one that I think guides us most is without undue regard to procedural technicalities. Because when we get technical in this court, then we lose the child. In fact, yesterday there was a child who said, our speeches are boring. That should tell you that our jargon is too complicated for children. When you say diversion, they don't understand. We always assume that these children understand what diversion means. We have to explain what this process is. In fact, I have asked the ODPP most of the time to bring the children at least a day before to just see the court. The courtroom is scary. And the judge is seated up, or magistrate is seated up there. This child is supposed to appear before you looking up there. And really scared. If adults get scared of the court, not just adults, even senior advocates, I see them at times, trying to imagine who is in that bench, And this is now a 13-year-old appearing before me, looking very serious. What I'm going to talk today about me, the children's court. Any other space, everybody has spoken for themselves. Today, allow me to talk about me as a children's court. What does Section 92 of the Children Act tell me? That I should create a child-friendly space. Does it mean that I play around with the child? No. It means that this space should accommodate the child to speak their mind to the court. Of course, in an orderly way, in a controlled way so that we also don't abuse the process because it's still the court. But this child should be able to raise their hand and tell me. In fact, in all proceedings, we ask them, do you have anything to tell the court? We invite the court to, the child to talk to us. Out of all these things we have discussed, do you have anything for me? Then they say yes. My mother is not telling the truth. She's the one who has done this, this, and this. And I must record that, because that space is friendly for them to express. And another thing we should know is a child in conflict with the law is a child in need of care and protection. First, before they are anything else. Before they became a child in conflict, there must have been a need that was not met. Mostly a parental need. So all children who become children in conflict, we have done research and found that they were once in need of care and protection. Why did you steal? We stole because we were hungry. Why did you break into that building? We didn't have school fees. There will always be a need that was not met and is now being, quote unquote, met by the justice system in terms of that need. Mostly, it's a parenting problem. It's a parenting need. So we start by treating them as children in need of care and protection. So when they appear before me, Section 224 says I have two processes here before me. And it's not coincidence that A is diversion. It means as a court, before I consider the judicial process, I must look at A, being diverting the child, if this child is divertible. Then 227 of the Act again says, when to consider diversion. It says any authorized officer or judicial officer, but authorized has come before judicial. It means that child is a pre-charge diversion. Before they reach the judicial process, there must have been somebody who deals with that child before they reach court. So court is a measure of last resort in this process. So this child is supposed to be processed by any authorized officer and considered for diversion before they come to court. Who are the authorized officers? If you look at the Act, we have the police station is an authorized officer. In fact, to explain diversion, while you came here, you must have maybe broken a traffic rule. Some of us here were diverted, at least the last 30 days. Instead of going to court, you were diverted by the officer there on the road. And you offered an apology. Sitarudia. What was that? So we are also recommending that the police officer, by the time you come to report, especially parents who say this child is truant, I want them to be handled by the police. That is a child, a candidate for diversion. The chief has been recognized. The children officer, probation officer can divert. Prison officer, even the doctor, the registered medical practitioner has been recognized as an authorized officer. But their space now applies to reporting incidences of abuse in the facility. The labor officer, the teacher. So I want to focus on the ones that we have worked with. The children office has the greatest responsibility under the Act. It's now called the State Department of. No, you must say it in a manner that makes us celebrate. That we now have a department. It's called the State Department of for Children Welfare Services. So that department has the greatest responsibility in terms of being an authorized officer. The police station, the Child Protection Unit, we're expecting that this child is processed by a CPU officer. So we're not just saying a police officer, it's a CPU officer who is trained in children matters to handle children. Then the community can actually take this child to the chief and say, we are having a situation here, and we ask that you intervene. School has also been, the teacher has been mentioned as a diverting officer. So we have teachers who have diverted children At times they have suspensions, at times they have counseling sessions. Diversion also happens in school. So if you look at the diversion points under the Act, you'll find that the children office, the police station, the community through the chief, and the school. What is a preliminary inquiry? What is this? It's an inquiry. A child's first appearance in court. Let's assume today I'm now in court at 9 o'clock and a child appears. The first thing I need to do as a judicial officer is conduct an inquiry. Not to take plea, conduct an inquiry. That is the first thing I need to do. It shall, mandatory. His or first appearance is as contemplated in the CPC. That is the first. Instead of plea for children, we do PI. What are the objects of this PI? We sit down as the stakeholders and ask ourselves, how does the assessment report look like? Because the officer has already informed the children officer, we are suspecting that we have arrested a child. Can you come and assess for us? That assessment should be done by the children office. So I get to see the report. It has the age or estimated age, the criminal responsibility, whether we need further assessment. You might have a child who we suspect could be autistic. So I would want a further assessment to see what else can we understand about this child. Then a very crucial function of the ODPP here is whether the matter should be diverted or not. The person who has the police file before this court is the ODPP. So the ODPP goes first in terms of this is what we want to divert. Or I have evidence that shows that this case is not divertible. I have insisted that we must include that role of the ODPP to guide the process in terms of, you have interacted with the police file, you have the evidence. Can you also tell us what options are available from your point of view? And then we also have diversion options. We also discuss it in the preliminary inquiry. Or if you say this case we are not going to divert, the ODPP submits and says we are not diverting this case, then we forward it for plea taking. But at least we have conducted the preliminary inquiry. And we also ensure that all available information relevant to the child, his or her circumstances, and the offense is considered. You might find that this child went to defile other children. If you look at the history, they will tell you, I was also defiled. And that is how I am going to respond to my trauma. I will make sure all the children go through what I have gone through. We discover that in the PI. So we also look at placement, decision on diversion and placement of the child. This is collective responsibility. No agency takes the lead here because we are discussing. The court also comes to the round table to have a discussion with the child. So we all talk. Everybody gives us their views, including the victim who has appeared in court to say, no, in fact, don't even think about this case. I want to forgive this person. In fact, I have a matter where there's a neighbor who says, don't bother processing even diversion. I just want this child to say, Pole. So do you still want to continue with that case? Yet the person who has been offended is saying, forget about these meetings you're having here. I want to go to work, and this is something I can sort out with this child. This is our neighbor. So at that point, the role of the DPP, the role of the court, everyone else says, okay, fine. We will accept the apology and then process the child. And we close that file at that point, and the PNC file continues. Ensure the views of all persons present are considered. Encourage the participation of the child. The child can say, I am not the one who did this, but I can send you to the person who told me to do it. I'm the one who did it, yes, but somebody sent me to do it. The views of that child should be considered at that point. And then we now determine whether to release or proceed to placement. We conclude the preliminary inquiry, the appearance of the child in court, or referral to the next court to process the child. The power of the court in diversion. Upon ordering diversion, I want us to now listen to the act. Upon ordering diversion, The magistrate conducting the inquiry or proceedings shall identify a children's officer, probation officer, or any suitable person to monitor the child's compliance with the identified diversion option. So again, that role has now shifted again to the children officer or probation officer or any other suitable person to monitor the child's compliance. There is a child I diverted to school, and the teacher, we agreed would be filing a report on the conduct of this child. And that works, because then I am able to know, have we helped the child? After we diverted, did we help this child? And we will mention until that child is now okay to stand on their own. And we don't close the P&C files until they turn 18. What are the levels of diversion? When you appear before me, we will all assess the case in the PI and say, this one, an apology do. We can also do caution and tell the child, now that you have appeared before court, let this be your last time. And that one has worked. I've seen jurisdictions where it's called what? Admonition is recognized. You just tell the child, yes, you have come this far, but I want to give you a second chance. Don't do it again. You can also place for supervision or guidance. We can also order for family time order, especially for children who are truant. We say every Saturday, you should be home between 9 o'clock with your family and 4 o'clock. There's no leaving home unless you're living with your family. So we give you a family time order. And this should not exceed 3 months. We go to the second level. We can divert straight into community service. There's a child who had run-ins with the police. And I told the child, you know what? And every Saturday morning, for 2 hours, you'll be at the police station, watering the flowers. In fact, he ended up planting more, and they said, no, this one we will paint. And they ended up doing that. And he brought his friends also. They helped and they painted, under the supervision of the children office. And that was done. We can also refer to education. There's one who tells me, Your Honor, I left school in class 3, and we now get into vocation school. And we used to partner even with Machakos Technical when I was in Makadara. And they would take all our boys there. They go for school, and then after that we, of course, most of the time called for the graduation, but the court does not have time to attend. But we get to file the certificate and close the file. We can also have the matter referenced. It's family group. The matter is referred to the family group discussion, which I'll discuss in a few. And then this level 2 should not exceed 6 months. Then we have level 3, which is intense. The program should not exceed 6 months. If it is a residential element, does not exceed 35 days and 23 consecutive days. Performance of community service without remuneration. I'm glad even the universities are now introducing something called service-based learning, where you go into an institution and provide services. I know of a university that asks their students to do 300 hours of community service without pay. So we are now saying these children can go and offer a service without pay, and then we stipulate the amount of time. We also send them to the vocational or educational for educational purposes for a period not exceeding 6 months and for not more than 35 hours in any week. What is FGC? This one is convened by the children officer. The family group discussion is in level 2, and the children officer is supposed to notify the parties within 14 days of the place, time, and setting of the conference. I'm glad we're going to have a simulation of a family group conference. We also take steps to ensure that all persons who are required to appear at the conference are given adequate notice. Who appears here? The children officer, summoning everyone else, probation officer, ODPP, and the victim of the alleged offense. Who else? Any person requested by the child can say, I want my uncle to be with me, especially if the parent is the complainant. We have seen very many parent-child conflicts in court. In fact, there is a mother who comes to court, the mother who came to court and told me, I am tired, take this child. I've given you for free. In fact, I can sign everything I give. This child has disturbed me. So in that case where the mother or the father is the complainant, the child can request, I want to have so-and-so attend. The legal representative, we can't leave away the defense counsel. This person has to sit there to represent the interest of the child. Member of the community in which the child resides. At times the chief would want to appear. In fact, I have a chief who brought a child and said, I want to be part of the process and I also want to rehabilitate. A counselor or psychologist can also be present, especially for issues that are parenting related. We recommend the psychologist is present. What is our practice? The court convenes the child justice practitioners in a PI conference. We have a discussion is heard on the background or the criminogenic tendencies. You might be told this child has been doing this so many times. So we sit and discuss what those issues are. In case of diversion, of course, we have a PNC file opened. We proceed with the PNC file because we must monitor the progress. It will be in vain to divert a child you're not monitoring, a child who is not accountable to you as a court. Many children I can report, 1 out of 10 would go off, but most of those children would follow through until they finish. The first child I diverted while in Makadara is now in the university. We diverted, it was in Form 1, that time Form 1, it was a case that ideally we wouldn't divert. We didn't have the guidelines, and I was holding on to the UNCRC because then it was challenged everywhere. Where is this practice coming from? And I said, it comes from Article 2. Of course, it brought a lot of conversation around it. And I'm glad ODPP now ran with the diversion. And we said, one day I'm going to call him to just tell his story about how we handle him in the justice system and the things that he's been able to achieve, knowing that yes, I have committed an offense, but yet I was still accepted. Because some of these children already experience stigma. But if the court accepts and these parties are willing to support the child, then we will rehabilitate very fast. So for an FGD, I'm glad our children officer is here, Madam Nyaranga. I'm glad she's here. Maybe she spoke yesterday, but Judge, you haven't seen you've met her. She's very good with handling children. And especially there was a matter where even ODPP was sued. And we handled it. It was pre-charge. They refused to charge. In fact, this is the time where we sat with ODPP and said, you know what? We are going to support you in this. And we had FGD for the longest. We almost spoke every day because the father was very furious about the diversion. We diverted the child. So Halima, not her real name, tells me, even if you charge me, I love the guy. I will give everything for him. Even if in fact, you charge him like this, I have already bought the poison. I'm ready to die for this love. See that love it's called On the Rocks, or what it's called what? You know, that love that you were told about. So Halima was very adamant, and I decided to have a meeting with her. Didn't she give me her TikTok page, and I saw things at my young age. it, I couldn't believe. And then at some point when we are closing, she brandishes the picture of the boy and say, Your Honor, this is him. Even you, Your Honor, you see the way he's handsome. And I agreed. So Your Honor, even you, what will you do? So we sat down, and the parents of this side were not agreeing. I told them, you're officially in-laws. Because now what do we do? Their age is almost not very far apart. The girl is madly in love. What do we do? Because she will kill herself. So I had a choice as a court. Do I let her die? Or can I rescue this girl? And we rescued on one condition. She goes back to school. Because I said, even if you love him, you're not going to ask him for sugar every day. He'll get tired. So you also need to go to school, work, and also provide for this family. And they both agreed that we will go to school and we will not get children. So I don't know, I did not ask how, but the girl told me, it's been 3 years, have you seen me pregnant? I don't know what she's been doing. But that is what diversion can do. That is what it can do. What is our way forward? We need to have a trauma-informed justice system for children. This trauma is being romanticized, but it is a real issue. A trauma-informed justice system. We can make or break these children at a very young age. We have the power to mend these children at they say samaki, there's that samaki pot. That you samaki you kunja when? Angali beach. So let's kunja the samaki now. Let's train our authorized officers. They have so much power because they are on the ground. The chief is a good resource. Let's train them for pre-charge. That is now what I was talking about, the prevention. Because when they come to the justice system, they learn things that ordinarily they wouldn't learn. There's one who told me, Yona, when I went there, I was asked, yours was just stealing. You have not even involved a knife. So they ended up learning things beyond, over and beyond what they had been charged for. Let's engage our child justice counselors in all the spaces. There's a jurisdiction, I understand they have son therapy. They have a therapist in every point of call. The police have a therapist, the children office have a therapist, the court has a therapist. These children are covered end to end, and these therapists are trained. We are now currently working on the training manual for the therapists so that we standardize the practice. Let's also establish diversion programs. I want to recognize Osiligi. Osiligi is a place I have gone. I've eaten their food. They have trained some of these boys to do, it's called what? Aquaponics. Most of the letters you take at, I'm told time is up, you take at Carrefour, for instance, come from some of those boys. They supply the best letters. They are trained how to do agriculture in a technologically, they use technology, they use AI to predict the weather patterns, and they're able to plant using AI. That for me, I found to be something we need to emulate. Then of course we have the Hogoshi. At what point are we going to have volunteer probation officers to follow through with these children? I know this is a Japanese word. These Hogoshi stay in the community and they help these children, rehabilitate them, have coffee with them. They spend time with them. They check their progress way over and beyond what the courts can provide. Then the sub-county children advisory committees can oversee the diversion programs. We already have the structures. We had a diversion toolkit, which I think we can officially roll out. Look at it again. Madam Juliet, this one you've been very proactive on, and now we're going to do a way forward, but we already have a diversion toolkit as a way forward. Can you also create a service provider directory? Because I don't know the children officer, I don't know who the OCS is. Can you have those numbers? Not attached to an individual, but attached to the office. So that if I need to call, I know the sub-county children officer is 07 this, OCS is 07 this. Let's have a service provider directory across, because the justice system needs to talk to each other. Work on the prevention strategy. Go to schools, for instance, and talk to these children the sub-county children advisory committees can have a teacher seconded there to go to the schools and talk to them about against crime. I mean, just look at the area and see what crimes are prevalent, and that can be done from as early as before they come to the justice system. Then use of technology in AJS. This we will be ready to partner. We started the first ever criminal justice end-to-end. During COVID, we were able to manage technologically all processes from the police station, the children office, the CCIs we were able to do, and maybe officially launch the Child Justice Information Management System, that all of us can know the progress of these children, can be fed in the system, we can work on the ethical considerations there. And with those many remarks, thank you very much. Oh, questions? I don't know whether, thank you, it's child friendly.
Thank you so much. That's actually child friendly with the colors. No. Thank you so much once again for the presentation. Some of us just hear these words, we don't know where they are in the law, we are not sure where exactly to find them or what they mean exactly. But this is the session where we get to hear all that. And in the evening, we will have all those ideas collated into our action notes that we'll be using when we leave here. Yes? I think we can have the, you have a burning question. I think we can have the question because we have the whole after tea break session for the simulation, which is on the same thing that she has actually presented. Can we have the questions then? All right, thank you so much. And yours is the first one. Thank you so much. At this point, join me in welcoming Honorable Teresia Matheka, who will just say hi to us and invite our keynote speaker.
Jambo tena. Kwani mnasikia baridi? Oh, sikusikia ni kuhisi. Good morning. How is everyone? Haki mnaongea ni kama mmekasirika. Mko fiti. You know, for those of us who deal with children all the time, we like to read the mood and just wonder, is this child okay? So I'm looking at the child in you, and I'm not seeing a happy child. In fact, I was saying, hiyo picture ya mtoto ilikuwa pale. I was telling daktari we should all do. And maybe that's what we should do. Yes. Please, let's stand up. You remember that picture that was there? For the sake of just changing the mood in the room. Please. Kidogo tu. Can you remember the picture? Yes. The one did you see it? What was the kid doing? Or I don't know which one, but the one you like, just stretch if you can't do the kid thing. Oh, thank you. Please have a seat. I'm not giving a speech. I'm not making a presentation. I just thought I would project something which I like to project. But mine is to invite Prof. But before I do that, allow me to take one of your minutes. One is what I call a moment of silence. And for us to breathe in. There's been a lot of things said about this justice system, this child justice system, and the way in which we are looking at access to justice for children. I like what my brother said, that we need to look at the law, but I also like what everyone else is saying about what we need to do about children and the alternatives to the justice system. But the thing that we must remember is that the child cannot wait. The child cannot wait. There's a quote I love. Sorry, there's a quote I really love. The things that we can't do, we cannot do is just remember the child cannot wait for us to be doing these things. We must do something right now, not tomorrow. And this quote, and you've heard it from me many times, just says, from someone, I'll say her name, we are guilty of many errors and many faults. But our worst crime is abandoning the children, neglecting the fountain of life. Many of the things we need can wait. The child cannot. Right now is the time her bones are being formed, and also the intersex child. His blood is being made. His senses are being developed. To him we cannot answer tomorrow. His name is today, Gabriela Mistral. Everything we are saying here is good, but we cannot afford to continue having different ways of looking. We must sit together and say, this is the child in conflict with the law. What do we need to do? Whether it's judiciary, DPP, everybody else. The child is not sitting here. I'm told the child was here yesterday. They are not here today. That is my call to action, that we must sit down together and do something about this. We are lucky because we have this law that has changed the way we look at things. We are very lucky we have this constitution that has asked us to refocus our minds away from certain things, what I call kasumba or something else, to a new way of looking at the future. And we must do that for what we are calling the future of our nation, which is the children of this country. I cannot live here without directing our attention to Section 144 of the Children's Act and what a child in need of care and protection is. And we are told the child in need of care and protection is a child who lives in difficult circumstances and needs to be protected from all kinds of neglect, abuse, and exploitation. The child in conflict with the law is a child in need of care and protection. And I want to ask every one of us in our different roles that before we think about anything else about the child, tunasema amevunja sheria, we remember that before they vunjad the sharia, allow my English and Kiswahili together, they were a child in need of care and protection. And Section 144 gives us the categories: an orphan, abandoned, begging, receiving alms, lost and found, whose parent is detained, all those things. Please go and look at it. Parents who are unable to parent. And those the children that you meet, Honorable Kibosia, every day. Parents who are terminally ill. Parents who are fighting every day, domestic violence. Parents whose family is threatened, in danger of something by a member of the family. Are victims of human trafficking and all those other things. A child who's pregnant or who has made another child pregnant. All those are children in need of care and protection. And they end up in our courts because something, those children, if you look at it, something fell through and they found themselves there. I needed to say that, so that when we think about the child in conflict with the law and all those alternatives that were placed up there, we think about that child and the fact that by the time they came to where we are putting a charge sheet in front of a court, we have to think of where they were coming from so that we can create that future for them as citizens of this country. My brother Omwenga, you said something, and I think I have a right to reply about the revision. That the court was asking you to file a reply. This one I couldn't hold myself. I'm sorry I have to use this platform. Because the court has the discretion to hear parties and for parties to file a reply if they want to. Section 365. Parties don't have a right to be heard, but the court has discretion. I'm one person who says DPP has a right to be heard during a revision. And I ask them, do you have anything to say? And if they do, I will consider it. So I thought I must say that. And with those many, many things, it is my pleasure, my honor. In fact, I was wondering, Prof, will Prof come? Then I saw you sit there, I was like very happy because I was like, hey, we are talking about access to justice for children. I'm looking forward to what it is that you will say because I'm sure it will make a very big impact. So, PLO Lumumba is an advocate of the High Court of Kenya and Tanganyika. Okay. That pose is meant to say something. I don't know if you are still focusing. Served as the director of the Kenya School of Law and the Kenya Anti-Corruption Commission. He's a founder of PLO Lumumba Foundation and a notable Pan-Africanist. I watch your videos. And has delivered several alluring speeches on Africa and developing African solutions to African problems. Today, we are confronted, I think, by the biggest African problem, what to do with the children who find themselves in conflict with the law. You've seen the figures of children in detention. So we are looking forward to your contribution to this very important topic. Karibu sana. Makofi kwako. Karibu sana. Karibu sana. Karibu.
Thank you very much. Let me start by thanking the organizers. I'm not going to deliver you a typical keynote address, but I'm going to tease out a few issues which I consider to be relevant when one talks about children in an African setting. I do this because I run a foundation which has been in existence for 30 years. We are present in 46 African countries, and we deal with young people. So I speak from a purely practical standpoint, not just because I'm a lawyer. And I remember very vividly, many years ago when I served as the Secretary of the Constitution of Kenya Review Commission. We traveled across the country during that period, and we listened to many people, including children, and some of the provisions that you now find in the Constitution. Article 53 has remained alive in all the drafts that were written, from our own CKRC draft, moving to the Boma's draft, moving to the rejected Wako draft, and ultimately the Constitution of Kenya 2010. In those early days, we thought about criminal justice system in a broad way, and we reminded ourselves that our criminal justice system, as is our legal system, is still very neo-colonial in character. And some of the recommendations that we made, which have found themselves into the law, included, among other things, to change the name of institutions so that the prison became correctional institutions. We hoped that changing names would, in the fullness of time, also change culture. Whether that has happened in the manner that we desire is debatable, and as others would say elsewhere, the jury is still out. We also took the view that we should change the name of the police force, and we said it would be a police service. Whether the trainers at Kiganjo understood that change as not merely being cosmetic is yet another debate. And we did so because we believed that you needed to change things fundamentally. The other thing that we did was to remind ourselves that even the institution that we inherited relating to children, Boston institutions. Boston is a village in Kent, in the United Kingdom, out of which Boston institutions came. It was informed by the reality in Boston. So it could very well be Ndumberi institutions if these things had happened in Ndumberi, in Kiambu. But I stand to be corrected. I still believe we have a Boston Institutions Act, Chapter 92 of the laws of Kenya. We also have something called approved schools and rehabilitation now. Kabete used to be famous or infamous, depending on who you are talking to. And it used to be the place where unawapeleka watoto watukutu. That was Kiswahili that was being used. Mtoto akiwa mtukutu, unampeleka. So a lot has changed over the years. Mr. Mwega posed the question, which was rhetorical but relevant. Do we leave the Constitution? The answer is, it is work in progress. We make our 10 steps forward, then we make 5 backwards. But it is Maya Angelou who said, we must endure defeat, but we must never be defeated. And I think there is merit if you look at the underpinnings of that statement. Today, we are gathered to ask ourselves a very practical rather than an academic question. Is our justice system friendly to children? We have a forest of laws. The UN has what is described as international standards, and I now, as I grow older, ask myself, is there anything international? At the African level, we have cascaded it down and we call it the African Chart. But is there anything that is so homogeneous as to be called African? Or it is so heterogeneous that even if you are to come to a place such as Kenya, that heterogeneity is evident in our different communities. And being sensitive to those realities, how do we deal with it? When we train our young men and women in our institutions of learning at the university, children's law is still optional. And very few actually take the subject because they think it is a soft subject that ought not to be taken. It's not the kind of law that you want to learn about. Should it be compulsory? How do we teach it? How do we inform our court systems? When you go to the Judicial Training Institute, do they have specific courses which are not tokenist that address that particular segment of the law and practice? When you are talking about the office of the ODPP, do we have prosecutors that are trained specifically or they learn on the job? Even our judicial officers, don't they just learn on the job? These are critical questions that we must ask ourselves as we talk about children and the law and in the ecosystem that we call the criminal justice system. Many of you, particularly judicial officers, when you visit what we call correctional facilities, can they correct anybody? Or they are breeding grounds for hardening people? Do our police officers have the sensitivity and the training and the discernment that enables them to filter and sieve young offenders? And the answer is, they are seen as watoto watukutu. I live here in Nairobi and grew up in Nairobi, and on Sunday I was, as I normally do, drove to where I lived in Jericho, Maringo, and Eastleigh on Sunday afternoon. And it's worse now than when I lived there. And when I talk to those young boys, and even girls now, below the age of 15, they are high on something. And when the police decide to make a clean sweep, they find themselves at Kamukunji police station. and their parents have to pay money before they are charged with this or that offense. There used to be an offense, the good judge will remember. Umepatikana na hatia ya kuwa mhuni na mlofi. Yani ulikuwa ukirandaranda ukiwa na nia mbaya pengine kuiba. You remember that offense? I think it is now off our books. But it used to be very common when you sat in Makadara or Kibera. It used to be there. And many times, because we were victims and prisoners of the English language, the charge sheet would be read in English and would be interpreted in very poor Kiswahili by those court clerks whom you know. And then you ask them, umekubali haukubali, and they don't know what to do. Those were the dark days, if you may. A lot of changes have taken place. And when I listen to you, it gladdened my heart. I hope that the rhetoric is close to the practice. And that the attitude that you have and that the environment that you have is one that is friendly and that it ought to be improved on a daily basis. You know, I do not know whether you people read and reread books. But the book that I read and reread and is on my desk, I have 3 copies of it, is Chinua Achebe's Things Fall Apart. It's on my desk at home, is on my desk in the office and on my bedside too. And I read it. And chapter 10 of Chinua Achebe's book speaks about a trial. There are 2 trials actually, but the one that is reported is about a man who was in the habit of beating his wife, what we now call gender-based violence. And there is a jury trial, and the chief, who I call the Chief Justice of the Supreme Court of Umuofia, is called Ivo Forrest. There are 9 of them. And Achebe tells the story as they are joining the bench, as it were, that the wives of Achebe saw that Okonkwo's seat was empty. And they also could see that one of the Gugus had a springy walk like Okonkwo. And all the Gugus or the elders of the tribe wore masks. And they represented the 9 villages of Umuofia. And as they are adjudicating, Ivo Forrest says, the body of Uzoulu, do you know me? And Uzoulu says, you cannot be known, you are unknowable. Then he tells him, I'm the dry meat that fills your mouth. I am death that takes your life when it is sweetest. Ultimately, the case is hard, and the man is ordered to take back his wife, and the wife is ordered to go back, and some things are taken. That is African judicial system. Justice is instantaneous. The judge does not retire and tell you judgment will be delivered on the 9th day of September. It is instantaneous. It is communal. And for that reason, it is acceptable. I think it is the learned magistrate who posed the question when somebody, was it Omwenga or was it the learned magistrate asked, if somebody comes from committee, do you welcome them back? In certain communities, many rituals have to be performed. If you are charged and convicted with a particular offense before you enter home, and I'm not speaking about the Middle Ages, I'm speaking about now. Because they say umekuja na mazinga ombwe mengi tu. The question therefore, as we talk about alternative justice systems, I personally am very reluctant to use the word alternative. Alternative to what? Alternative suggests inferiority. I'm one who talks about, for want of a better term, African justice systems. We have relegated our justice systems. When the Honorable Magistrate talks about diversion, what is a Gikuyu word for it? What is the Kamba word for it? What is the Luo word for it? And the statistics that you gave were very telling. I think it is Mr. Ludo, the advocate, who gave the statistics about only 17%. What you see in our criminal justice system is the tip of the iceberg. Many of these problems do not come to the court system or to the judicial system. They are dealt with in different fora. And if you go to informal settlements such as Korogosho, Kuwinda, Mkuruko, Njenga, Mkuruko, Yaba, Yizogoro, they have their own systems which deal with this. The good doctor here knows, because many of you are in these spaces. So that out of 10 transgressions, perhaps the criminal justice system receives at the very best 3. How do we mainstream these things? Somebody talked about Nyumba Kumi. Our Nyumba Kumi is still very weak. If you want to see a strong Nyumba Kumi, go to Tanzania, Tanganyika, or mainland Tanzania. That is where Nyumba Kumi is. Ours in a sewer even. But when you make sure that you have them at that level, in African systems, which I hope that you who are dealing with these systems will want to mainstream, a child belongs to the community, or so it used to be. Today, particularly you who are of the middle class, even if a teacher as much as shouts at your child, how did he shout at my darling, my Jenny? And you go to school, children, parents go to school to confront teachers. And they don't even have the patience to listen to what was happening. How do we deal with those? Yet the Kiswahili saying is, mtoto mleavyo, ndivyo akwavyo. And during an earlier debate, I'd actually used the thing, samaki mkunji angali mbichi. So you practitioners, there is work to be done. A lot of work to be done. Right now, if you look at the criminal justice system, and I work with a number of countries whose refugees are present here in Kenya, in Kakuma, Burundi, South Sudan, Cameroon, the Democratic Republic of Congo, you will be amazed at what is happening with those camps and how they are dealt with and how they don't reach the criminal justice system. This idea that you separate adults and minors in police cells is fiction in many cases. It's like what we do in Nairobi in middle-class houses. You separate garbage, food and others, you separate them in your house, but the person who collects the garbage mixes them immediately. So that the entire enterprise is a waste of time because we don't have a system of dealing with them. So in practical terms, what am I saying? I'm saying that on paper, we are in a good place. If you look at the UN system, the African system, you look at our constitution, one cannot quarrel with what we have. Look at the provisions that we have looked at. The ODPP, who are active in this space, the learned magistrate active on a daily basis in this place, and you interact with the law in action. The law is innocent. But remember this old cliche that culture eats strategy for breakfast. What is our culture? The dominant culture has still not developed to the levels that it can accommodate and create an environment in the manner that we desire. So we have the framework, we have the form, but the substance is work in progress. I look forward to the day, and I think this happens in Sweden. In Sweden, those who want to join the bench actually take an extra year. You stand, I'm sure you've gone for visits to Sweden. They take an extra year to train as judges so that you are able to determine what it is that you do in specific circumstances. And we are the youngest continent on earth. And therefore we ought to know how to deal with young people, both in conflict, and the conflict is no longer just the mega conflict. The conflicts are in the domestic arena. Unaishi Kibera. You're in a single room 10 by 10. You have 10 children. You are working in a building site. You go there on a daily basis, they are only accepting 200, there are 1,000 of you. No guarantee that you'll be employed on a single day. 10. In 10 by 10. The conflict that emanates in that environment, and you did give as a cameo preview of it, is that parenting is collapsing. Therefore they say, tumpeleke kwa polisi. And one of the threats is tutakupeleka polisi ili ufundishwe. How do you deal with them? Even when they have gone through your system, are they rehabilitated? The answer is no. Do we have the facilities to do it? Those of you who drive on Uhuru Highway and are in town, have you seen the number of young people begging now? I remember at one time when Joe Akech was the mayor of Nairobi, he caused them to be picked up and to be taken to YMCA and all these other places. I want you, as you drive on Uhuru Highway, see the number of young people sleeping under the expressway. Petty theft, side mirrors, wheel cups. Then they are charged and taken to Makadara, taken to Kibera. They have no identity cards. Wewe unasema uongo, wewe ni miaka 15, 19, and the boy is 14, because they are also stunted because of nutrition. There is a study that shows that children who live next to this dump site in Dandora were stunted. Because, do you know that thing in Dandora, there has been fire underneath it for the last 30 years? Releasing toxic waste, and there is a study on it. So you have many young people going into the criminal justice system as if they were adults, and they are not. How do we deal with that? How do we ensure that our prison systems or correction facilities are accommodated? I haven't been to Kabete Rehabilitation Center for a long time. I would wonder what it looks like. The Boston Institution, I know there is one in Machakos or somewhere which engages in community activities. How are we engaging them in community activities? In my rural home, it used to be the case that when you are a changa drinker, when you are found, you are just told to go and cut grass at the chief's place so that your wife can see you being humiliated. And when that happens, then you behave. Do we use those systems? As I conclude, I want to say that this is a critical opportunity, and don't just look at Kenya today. Look at the continent of Africa. Look at the number of children who have found themselves in adult environments, in Sudan, for example, now. They are all in charge, people aged 14 and 18 and below, heads of families. What are you going to do about it? Here in Kenya, with the withdrawal of USAID aid and the return of HIV/AIDS, what is going to happen to child-led households? The level of crime, with the borderization of our economy. Because border must not be, you must not think of it just as border. We have borderized the economy, and I'm told there are 3 million borders in Kenya today, and growing. I don't want to say what is happening, but a border person is a liquid person. And a border person meeting your Halima makes sense, because a border person can earn 500 and dispose of 200 to take care of Halima's sanitary pads. And if they increase in number and they can't get work, and some of them now get out of the school system in Form 4 and they go straight into border because they say even graduates don't get jobs. What are you going to do about it? I've heard the UN speak. I've heard the African Union speak. I've heard our Constitution speak. I've heard the Children's Act of 2022 speak. I've heard the ODPP speak. Culture is what must change. It is not for the faint-hearted. It is not going to happen over time. But engagements such as these are important. My desire is this. You have met at IBIS in style. Can you style up and now go to the villages? And when you go to the villages, make sure that this conversation is held in Kiswahili, that this conversation is held in Agikoyo, in Kikamba, in Dholuo, so that the people out there have the confidence to come out and speak in their mother tongue. The reason why criminal justice systems are successful in countries in the Scandinavia is because in Denmark they speak Danish. In Sweden they speak Swedish. In Norway they speak Norwegian. In Finland they speak Finnish. Part of our handicap in terms of criminal justice systems in Africa is that we are speaking in foreign tongues. And those foreign tongues sometimes, even us who are initiated, if you ask your typical advocate who is in running down matters, what is diversion? You think it is when there is a road construction and you are told to take the other road. So thank you very much. I wish you the very best.
Thank you so much. Another round of applause. And that's a big challenge to all of us today. I'm sure if most of us asked, what is diversion in Kiswahili? It is? Jambadala. Kuchepua. That is beyond the scope of our Swahili understanding. But the challenge here is that we need to style up. We need to take this conversation to the grassroots. The children yesterday told us to go where? Start with the slum. We start with Korogocho, we start with Kibera, and have this conversation in those places, in those hotspots, in the language they understand. If you have to speak Sheng, Daktari, we know you are very good in English. You put it aside and you speak in Sheng, right? So thank you so much. We have spent a lot of time in this morning session, and my work here is practically done. I will have usher us to the back to have some tea, and then after that, we are coming and the program will be taken over by the standing committee, NCAJ, who will be having their simulation, and then they can show us practically, because we have seen family group conferencing, we have seen all that, but we actually now want to see how it's done. We want to experience it, because not all of us have had the privilege of going to court, of interacting with the system in that manner. Some of us are students, some of us work in the civil society space and do not go to court. So that will be the chance for us to learn, and that is where we will ask them all the questions that we had, right? And we will answer those questions so that when we come back in the evening for the final session, developing the action notes and giving commitments as various organizations and various institutions, we are working from a problem-solving angle, having discussed all the issues and, or as Prof says, issues, and coming up with viable solutions that will take forward to the field. Thank you so much. At this point, all the speakers for the morning session will come forward for a photo session. At least you're first speaker, Doctor. Please join Prof for a photo, and then we will be dismissed.
No, once you write, you have to make it
Rosie, are we posing properly? Rosie, tunapose aje? Tell us how to pose. Trust me.
Jemima, when got another job? Jemima, you've moved across the country.